Today, we're talking about a major legal crisis that Trump is facing. No, not the Epstein one. There's many of them, so I'll be specific. Trump wants desperately the Supreme Court to totally erase the E. Jean Carroll case and the verdict there. He just filed a 33-page petition asking the Supreme Court of the United States to wipe out the sexual abuse and defamation verdict against him. But the way we look at it, it's sort of a run-of-the-mill case. And the only reason he's asking for special treatment is because he's the president of the United States. Otherwise, it really doesn't look like there's a valid basis to even have the Supreme Court review it. So we're going to talk about that today, and we're going to unpack some of the arguments that they're making and why it's likely to fail. But we'll see how the Supreme Court does here and if they try to suck up to Trump. I'm Shant Karnikian. That's Brian Kabateck over there. This is Civil Action on the Legal AF Network. Before we dive in on this issue, remember, hit that subscribe button, hit that like button on this video if you like this content, if you appreciate what all the other folks on the Legal AF Network do here. Brian, where do we dive in with this issue?
Well, I think it's important to point out, Shant, that you and I both have represented victims in sexual abuse cases, so we're really, really familiar with this. So let's also mention that what's important here isn't just the $5 million that E. Jean Carroll won. We'll talk about basically the facts of this case in a second. But it's also the $88 million that she subsequently won in a defamation case. So in the first trial, the reason for the defamation in the first trial and the second trial is because Trump went around saying, as he would say, very nasty things about her. About E. Jean Carroll. And what I find, so first of all, $5 million was the decision in 2022, I believe, which has earned interest since then. So my rough estimate that is probably $6.5, $7 million by now, that he owes her. $2 million was for the abuse. And what's the abuse, you may ask? That's the allegation that she made that a jury concluded was true, that she had been sexually assaulted by him in a Manhattan department store dressing room sometime in the mid-1990s, and $3 million for the subsequent defamation, not to be confused with the $88 million in defamation.
So what's the excuse for trying to get this in front of the Supreme Court? Because the Supreme Court doesn't just review any old case, and just being the president isn't enough to be a party being the president of the United States is still not enough to meet the threshold of the Supreme Court review.
Yeah, he basically raises, four key arguments. So let me just mention them for bullet points quickly. First of all is, you admitted too much evidence about my propensity for sexually assaulting women, bringing in a couple of witnesses and the Access Hollywood tape. We'll talk about that. Then the second is there's no eyewitnesses. The only thing is her testimony and my testimony, says Trump. And the third is this is all politically motivated. It's all a political motivation. It's a witch hunt. And the final one is really this presidential immunity under the Trump ruling in 2024. So those are the four arguments. Let's kind of dissect them.
I kind of want to jump into the responses to those and what the reality is. Really, the first one, the sort of improper propensity evidence, to evidence that Trump tends to do things like this or has done it before. I mean, literally the federal rules of evidence, because there's laws that dictate what evidence comes into a case and does not. And states have them, and the federal system has it. The federal rules of evidence, I think it's 415, literally specifically allows similar acts evidence to come in civil sexual assault cases. And Trump just hates 415 because it's bad for him. It's basically what Brian and I sometimes call, when we're doing cases, the bad evidence rule. You don't want it to come in, not because there's a law that says it can't come in. It's bad for him. So basically, his argument here is the trial judge let the jury hear too much bad shit about Donald Trump. But the problem he has here is there's specifically law that allows for similar acts evidence to come in. That's on the first one. The second one was, I believe you said, Brian, insufficient evidence. Him saying standard bullshit Trump talking.
Right. And this is the one that gets me, which is he's saying there's no eyewitnesses, no video evidence, no physical or DNA evidence, no police report, no contemporaneous investigation. So like we said at the beginning of this, we've handled a lot of cases on behalf of victims of sexual abuse. There's a lot of similarities in these cases. First of all, no witnesses. Almost never is there a witness to a sexual abuse of whether it be a minor or an adult. There's almost nobody that's an eyewitness. The second problem you have is that most victims are shocked and they don't go to the police. Yeah. We've had cases where children are abused. They don't tell their parents because it's a priest or family friend. So He wants to completely undermine the entire sexual abuse system that exists.
Yeah, but you know what our civil justice system allows for, Brian? Victims to testify, victims to present evidence. He argues that there's no evidence. I mean, the victim's testimony, the victim talking about what they went through, taking the brave step of getting on that stand and telling the jury what they went through. Our system allows for juries to believe victims, and that's what they did here. So that
which drives us straight into item number 3, political motivation. So his argument there is, this lady didn't even come forward until I was running for president, and then she came forward. Well, okay, let me liken it to a situation we've seen numerous times. A priest, a minister, a Boy Scout or youth leader. Suddenly, victim number 1 comes forward. And this would also be true, I guess, for in the Epstein case too, Sean. Victim number 1 comes forward and says, this happened to me. And then all of a sudden, there becomes a cascade of a waterfall of victims who say, oh my God, that happened to me. So Trump's running. Suddenly, witnesses are coming forward. Suddenly, there is the Access Hollywood tape. And all of this information comes forward, and she comes forward and says effectively, it happened also to me.
Yeah. So it's going to happen. Someone's going to come forward if they do, and someone's going to happen to be the first person that comes forward. If his argument had held any weight here, then every first victim in sort of a high profile or serial offender type of case would be, well, they only came forward because they saw this as an opportunity to get press or make money or something like that. And it would undermine every case of sexual assault. I mean, you know, the sad reality is these are despicable arguments for someone to make. I mean, it undermines the whole system. It undermines the bravery. Look, you have some technical legal argument. You want to argue about the federal rules of evidence. Fine. You want to argue about immunity, things like that. But to undermine the entire system, the civil justice system we have that's meant to protect victims, is just despicable. So,
Sean, so let's go to item number 4, which is the Trump ruling from 2014, where he's claiming that he has presidential immunity. So this is important to note, and I don't think we've mentioned this yet, but I think it's worth a quick mention, is that the trial judge and the jury made the initial findings. Trump already appealed this to the Second Circuit Court of Appeals, the Federal Circuit Court of Appeals. He made an appeal there that he lost. And then he asked for the entire panel, the entire Second Circuit to review it. So 3 judges initially review this in an appeal in the Court of Appeals. And then he asks all the judges if they would vote to rehear the case en banc, which means 11 judges are then selected. So there are plenty of Republican and plenty of Trump appointees who could have voted to rehear the case, and they didn't.
Yes, right.
So, this is a 3-time loser now. Lost in the trial court.
And look, just as a reminder, the Supreme Court, I mean, look, here's what I think ultimately will happen. Supreme Court hears 1% to 2% of petitions.
Maybe 1% to 2%.
Maybe, yeah, you're right. And they avoid fact-heavy cases that have to do with evidentiary discretion. They defer to juries and judges that made factual findings. They look at misinterpretations of law or conflicts of law. They look at things like that, circuit splits, issues like that. And this petition is like, I don't know, at best 30% law, and the rest is about political talking points and facts. So, I don't think the Supreme Court will look at this, but we'll see. I want to make that my last comment on this, Sean. I think this is a litmus test for me. If the Supreme Court grants review for this very run-of-the-mill sexual abuse case with, as you said, factual findings, the law on point, if they agree to hear this case, then I think that the Supreme Court is completely in his pocket at that point. Yeah.
On the other hand, if they deny review, that's going to be very telling.
Yeah, it is a good litmus test. So stay tuned. We'll see what happens. The interesting issue. I'm Shant Karnikian. That's Brian Kabateck. This has been another installment of Civil Action on the Legal AF Network. Again, if you like this content, we appreciate your support. Hit that subscribe button. Reach out to us. We like hearing from you. We actually read the comments. We read emails that people have been sending us, even getting phone calls here and there. So it's kind of nice to hear from you all. If there's something you want us to cover, we'll take a look at it. Thanks for tuning in, and we'll see you on the next one.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.